With regard to the prosecution's argument that the trial chamber erred by only considering comparable cases involving mass killings and not cases involving torture or cruel treatment, the appeal chamber recalls that in the present case, the trial chamber stated that it could not, and I quote, identify a case before the tribunal that may be said to involve the same offense and substantially similar circumstances as in the present case, unquote. Accordingly, it did not engage in a comparison with previous decisions on sentence and rather referred to its obligation to tailor its sentence to fit the individual circumstances of the case. The appeal chamber finds that the prosecution fails to demonstrate that the trial chamber disregarded previous comparable cases. The appeal chamber further notes that the trial chamber was aware of its obligation under Article 24(2) of the statute to take into account the gravity of the crime in its sentencing determination. The trial judgment is replete with detailed findings addressing the gravity of the underlying crimes involving the mistreatment at Ovčara and the subsequent execution of at least 194 of the prisoners and their burial in a mass grave. In recording these findings, the trial chamber took into account Mr. Mrkšić's conviction for murder, torture, and cruel treatment in assessing the gravity of the crimes. The appeals chamber emphasizes that the trial chamber must be read as a whole. The trial chamber's references to the underlying crimes in the sentencing part and its detailed findings in the body of the trial judgment as to the horrific condition in which the prisoners of war had been kept throughout the afternoon, the nature of the mistreatment to which they were subjected, and the way in which 194 of them were murdered, indicates that the gravity of the underlying crimes was properly considered at the sentencing stage. However, the appeal chamber is unable to determine how the trial chamber weighed the consequences of the torture upon the victims and their families, or whether or to what extent it considered the particular vulnerability of the prisoners. Nonetheless, the appeal chamber finds that the trial chamber's sentence of 20 years imprisonment is not so unreasonable that it can be inferred that the trial chamber must have failed to exercise its discretion properly. Accordingly, the prosecution fails to show that the trial chamber committed any discernible error in the exercise of its discretion by imposing a sentence that does not reflect the gravity of the crimes Mrkšić aided and abetted. In light of the foregoing, the appeal chamber dismisses the prosecution's fourth ground of appeal in its entirety. I now turn to the appeals regarding Veselin Šljivančanin's sentence. Mr. Šljivančanin submits in his sixth ground of appeal that the trial chamber erred when assessing his role and responsibility in the torture of POWs at Ovčara, in finding that the POWs were under his immediate responsibility, erred by considering his involvement in preventing international representatives from gaining access to the hospital on 20 November 1991 as an aggravating circumstance, erred in failing to consider his good conduct and demeanor as a mitigating circumstance, and did not properly take into account the sentencing practices in the former Yugoslavia. With regard to the trial chamber's finding that the POWs were under his immediate responsibility, the appeals chamber finds that Mr. Šljivančanin does not demonstrate the trial chamber's use of the words immediate responsibility is inconsistent with its previous findings regarding his responsibility for the POWs at Ovčara. His arguments are dismissed. With regard to Mr. Šljivančanin's involvement in preventing international representatives from gaining access to the hospital on 20 November 1991, the appeal chamber considers that it is not clear whether the trial chamber took this factor into account as an aggravating circumstance. The appeals chamber is thus not satisfied that the trial chamber committed a discernible error in exercising its discretion. Accordingly, Mr. Šljivančanin's arguments are dismissed. With respect to Mr. Šljivančanin's argument that the trial chamber erred in failing to consider his good conduct and demeanor as a mitigating circumstance, the appeals chamber notes that the trial chamber considered evidence of his good character when sentencing him. The appeals chamber notes that Mr. Šljivančanin did not make any sentencing submission at trial. Accordingly, his arguments are dismissed. The appeals chamber also rejects Mr. Šljivančanin's challenges to the trial chamber consideration of the general sentencing practice of the former Yugoslavia. In light of the foregoing, Mr. Šljivančanin's sixth ground of appeal is dismissed in its entirety. The prosecution submits, under its third ground of appeal, that the sentence of 5 years imprisonment imposed by the trial chamber on Mr. Šljivančanin is manifestly inadequate, because insufficient weight was given to Mr. Šljivančanin's role and responsibility, and insufficient weight was given to the quote-unquote objective gravity of the crimes. The prosecution also argues that a 5-year sentence has no deterrent value for people who will be similarly situated in the future. It seeks an increase in Mr. Šljivančanin's sentence to fall in the range of 15 to 25 years imprisonment. With regard to Mr. Šljivančanin's role and responsibility, the appeals chamber notes that the trial chamber duly considered how Mr. Šljivančanin's role and responsibility contributed to the commission of the cruel treatment and torture of the prisoners of war. The appeal chamber further notes that in discussing his role and responsibility in the sentencing part, the trial chamber took care to reiterate its findings with regard to exact scope of Mr. Šljivančanin's liability. With regard to the gravity of the underlying crimes of torture and cruel treatment of the prisoners, the appeals chamber first notes that the trial chamber did not elaborate in the sentencing part of the trial judgment on the scale and brutality of the crimes. However, throughout the trial judgment, it made a number of findings attesting to the horrific torture and cruel treatment of the prisoners of war. The trial chamber had found that the beatings inflicted serious pain and suffering, and that the conditions of detention at Ovčara, including the atmosphere of terror and the constant threat of violence, caused serious mental or physical suffering. In this respect, the appeals chamber notes that the long-term physical, psychological, and emotional suffering of the immediate victims is relevant to the gravity of the offences. The appeals chamber notes that the trial chamber indicated its awareness that in assessing the gravity of the offence, the overall impact of the crimes upon the victims and their families may be considered. In particular, the trial chamber noted that, quote, apart from a very few persons subjected to cruel treatment or torture, in the present case, the victims of the offences were all murdered on the day. The consequences for them were absolute. Close family members have been left without their loved ones. In almost all cases, the anguish and hurt of such tragedy has been aggravated by uncertainty about the fate which befell these victims. Unquote. The trial chamber did not make specific reference in the sentencing part of the trial judgment to the particular vulnerability of the prisoners of war at the time of the commission of the acts and the impact this had upon them, though there are findings to this effect in the body of the trial judgment. The appeals chamber observes that the trial chamber's consideration of the overall impact upon the victims and their families, as reflected in the paragraph I just quoted, focused on the fact that most were murdered subsequent to being tortured. The trial chamber did not explicitly consider in the sentencing part of the trial judgment the consequence of the torture per se on the victims or their families. As Mr. Šljivančanin was convicted only for aiding and abetting the torture of the prisoners of war, it is not entirely clear from the trial judgment how the trial chamber assessed the overall impact of the torture on the victims and their families in the determination of his sentence. While the appeals chamber acknowledges that the trial judgment, read as a whole, contains numerous findings to the effect that, in light of the murders of the POWs, close family members had been left without their loved ones, and that in almost all cases the anguish and hurt of such tragedy had been aggravated by uncertainty about the fate which befell these victims, the appeals chamber is unable to determine how the trial chamber weighed the consequences of the torture upon the victims and their families, or whether or to what extent it considered the particular vulnerability of the prisoners in the determination of Mr. Šljivančanin's sentence.